Good morning. It's a beautiful Monday. Balmy 46 degrees. Gotta love that. Let's talk about Miranda and the Sixth Amendment. Everybody's familiar with Miranda. Miranda rights, Miranda warning. You have the right to remain silent. You have the right to have an attorney present. If you can't afford an attorney, one will be appointed for you. Miranda is Fifth Amendment law. Now, you may be asking yourself, well, what about the right to an attorney? And Miranda borrows heavily from Sixth Amendment, right to an attorney. But the right to an attorney given to you under the Miranda ruling is a right to an attorney to protect your Fifth Amendment right against self-incrimination. There are lots of things in the Fifth Amendment, but the clause that we're concerned about is the right to not, was it right to not give witness against yourself or something like that? I forget the exact wording, but it's not really important. The issue is that the cops are really, really good at getting people to talk. Everybody thinks they're smarter than they really are, myself included. And the cops do this stuff day in, day out. They get people to talk. We've all seen it on the auditing videos. Cops get you to talk. That's why you have attorneys saying over and over and over and over and over and over again, shut the fuck up, shut the fuck up, shut the fuck up, shut the fuck up. Because cops get you to talk. You can't help it. Your pride kicks in. You think you're smarter than the cops because they're just stupid donut eaters, right? And they'll even play along with the aw shucks and the I'm not too bright. You know, look, mister, I'm just trying to figure out what's going on here, as if they don't know. And they get you to talk. Now, Miranda doesn't kick in when they're just talking to you. There's 3 basic stages of police interaction. And don't get too hung up on the name, but everybody knows when you're arrested. If you're on your way to jail, then you're under arrest. If they're booking you in, you're under arrest. That's easy. Detainment can get a little squishy. You can get a little squishy. Basically, detainment is if you're not free to leave, you're detained. They don't have to say anything at that time. I mean, if they pull up behind you and flash their lights at you and pull you over with their lights, they've detained you. They haven't said anything. They just flash lights at you. If you're not free to go, then you're detained. The third basic thing is a consensual encounter. Now, even if you say to the cops, I don't like you, I don't want to talk to you, if you don't leave, if you don't break off that contact by leaving, then you are consenting to that contact. It's a consensual encounter. I know you don't like it. This gosh darn dirty tyrant cop isn't leaving me alone. I just want to stay here and film in peace. And he's standing here talking to me. That's consensual encounter. Don't get too wrapped up in the name. That's consensual. This isn't sex we're talking about. You can consent to conversation just by remaining there. Now, your Fifth Amendment right to remain silent is always in effect. But as soon as you get arrested, that's when your Miranda rights kick in. That's a different level of protection. At that point, you have the right to remain silent, and you have the right to an attorney. And that right to an attorney is the right to an attorney at an interrogation. And that's to protect you from being preyed upon by the police in that interrogation. And if you, at that time, if you say, I don't want to talk, then they have to stop talking to you. for a reasonable period of time. And how long that is seems to change. It seems to be ever shrinking in the case law. So I'm just going to say for a time, for some unknown period of time. And then after that unknown period of time, they can resume it. They can ask you again. They can start talking to you again. I'm going to wait for you to go. There you go. Now, the right to counsel under Miranda, again, I'm being very specific, under Miranda, this is in the Sixth Amendment right to counsel. If you say, I want an attorney, then they can't resume the conversation until they provide you with an attorney, assuming you're eligible for one, or assuming you've provided them the details to contact your attorney. They cannot start talking to you again until they provided you with an attorney. So it is in your best interest to always, once you are arrested, demand an attorney. If you're going to go down into some hostile area, like a police station, and they're going to put you in an interrogation room, there's a very good chance they're going to get you to talk, whether you think they can or not. That's why they do it. Demand an attorney. Now, the Sixth Amendment right to an attorney, that doesn't actually attach until, depending on the way your state does it, but typically until you're charged. That little hearing where arraignment hearing, you'll see attorneys present at those, like public defenders, just really not doing a whole lot, but they're there. The state's complying. So that's the difference. So your Fifth Amendment right to remain silent is always in effect. Anytime you're talking to a government official, you have the right to remain silent and not say anything incriminating. And all attorneys will always suggest you do that. Shut the fuck up. The second step is once you're arrested, Miranda kicks in. Whether they read you those rights or not, Miranda's in effect. They don't have to read you a Miranda warning just because they've arrested you, because if they're not talking to you, no harm, no foul. And in fact, I've seen at least one case where the police arrested somebody, put the suspect in the back of their car. They were just driving. Weren't investigating him, weren't interrogating him, and he started talking. He engaged the police in conversation. You're not going to go after the skunk, dude. Come on. And, of course, he said stupid things that got him, that incriminated him. And then his lawyer valiantly tried to say, but he wasn't Mirandized. And it was a coercive situation, et cetera, et cetera, et cetera. He should have at least been Mirandized. And the court said no, he wasn't being interrogated. There was no interrogation going on. So they don't have to read you your Miranda rights if they're not interrogating you. And just because they don't read you your rights, if you start talking, you fucked yourself. So, right to remain silent anytime, all the time, every time. Miranda is after arrest. The Sixth Amendment right to an attorney kicks in typically at the charging phase. Once you've been charged with a crime, formally charged, like in court, that's when the Sixth Amendment right to counsel kicks in. So I hope that helps. I hope that clears some things up. I know it is a little bit confusing, and I agree. Miranda was kind of I like the Miranda decision, but it was kind of muddy on how they attached right to counsel to the right to right against self-incrimination. It's kind of muddy, made things a little unclear. They pulled in Sixth Amendment case law on a Fifth Amendment case. And that made the dissent very squeamish. But I can understand why they did it. Because people get, people say, I don't want to talk to you. And then the cops go, have a look, here's all the evidence against you, man. You're hosed anyway. You might as well make this easy on yourself. And people will do bad math, not knowing all the facts. And they'll accept what the officers say is true. And then they'll incriminate themselves. And that is not in the interest of justice. And I want to point out to everybody who thinks that that the courts are biased against defendants. I just want you to remember all these cases on the Fifth Amendment, on the Fourth Amendment, et cetera, et cetera. Like Miranda greatly expanded the rights of a defendant. It greatly expanded them. It is an explicit attempt to protect the suspect. And if the courts are so against the police, then why did the court, the highest court in the land, why did the highest court in the land say, police, you're being abusive. You need to slow your roll. You need to tell the suspect, you need to tell the defendant that they have a right to remain silent. You have to give them the opportunity to have an attorney present at interrogation. If the courts hated, or if the courts are so stacked against the suspect and in favor of the police or the DA or whoever your particular bogeyman du jour is, then you have a real hard time explaining that decision. Are the courts perfect? Absolutely not. They're not perfect. But are they stacked against the defendant? No. No, they're not. Anyway, thank you very much for watching, and have a great day.